The discussion so far covers one factual aspect of the matter, but there is equally another factual aspect, and this has a direct linkage to the Supreme Court decision in Basavalingappa. As we noted, the Supreme Court decision mentioned the States Reorganization Act in regard to the state of Mysore. Full stop. The present petition, however, have proceeded on the basis of the 6th September 1950 presidential order, then the 25th September 1956 SC and ST Amendment Act, and thereafter come directly to the 1976 Amendment Act. But there are certain intervening factors that must be noted, and these equally apply to the factual aspects of the matter, namely whether it can safely or fairly be said that the Dhangad entry in 1950 or in 1956 was of a 0-member class. Next. The 6th September 1950 presidential order mentioned in part 3 dealt with the state of Bombay as it then existed. Full stop. There was no entry for either Oraon or Dhangad in 1950 for the state of Bombay. Full stop. That the entries for the state of Bombay were in part Roman 3. Full stop. Part Roman 4 dealt with the then state of Madhya Pradesh. Full stop. In particular, it dealt with the Melghat Taluka of Amravati district and the Sorocha and Gadchiroli tehsils of Tanda district. So entry 26 in part 4 for the then state of Madhya Pradesh was Oraon. Next. Following this, on 30th March 1955, came the report of what is known as the Kaka Kalelkar Commission, Backward Classes Commission, and its recommendations. Full stop. For the state of Bombay, in a category of other backward classes, at serial number 82 was the entry of Dhanagar with a R, said to be traditionally cattle herders, cultivators, forest laborers, and sheep rearers, REARERs. For Madhya Pradesh, the recommendation in serial number 26 was of an existing list excluding localities, and it mentioned Oraon, but throughout the state of Madhya Pradesh, the sub-tribes of Oraon were said to be Dhanka and Dhangad. Full stop. Next. Then came the States Reorganization Act 1956 of 31st August 1956. Full stop. The appointed date was 1st November 1956. Full stop. Section 8 had the formation of a new state of Bombay, and it comprised inter alia the territories of Buldhana, Akola, Amravati, Yavatmal, Wardha, Nagpur, Bhandara, and Chanda districts, which were till then in the state of Madhya Pradesh. Full stop. Similarly, correspondingly, Section 9 said that the new state of Madhya Pradesh on the reorganization would include the territories of the existing state of Madhya Pradesh, except those mentioned in Section 8, brackets number 1, bracket C, namely the districts we have mentioned above. Next. This was 31st August 1956. Full stop. It is about a month later, on 25th September 1956, that there came to be the SC and ST Orders Amendment Act of 1956. Part 3 dealt with Bombay. Full stop. Part 4 dealt with Madhya Pradesh. Full stop. It mentioned for the territories of Melghat Tehsil of Amravati district and the Gadchiroli Sirocha Tehsils of Chanda district, as also the Kelapur Wani and Yavatmal Tehsils of Yavatmal district in entry 26. Oraon, including Dhanka and Dhangad. Full stop. There was no entry in part 3 of Oraon or Dhangad for the state of Bombay. Full stop. On 12th October 1956, there came the Constitution's 7th Amendment Act 1956. Full stop. Article 1 was amended and the states and territories were specified as per the first schedule. Full stop. This included the territories of Bombay as specified in Section 8(1) of the States Reorganization Act of 1956, and for Madhya Pradesh, those in Section 9. Full stop. Next. It is after this that there came the 29th October 1956 Scheduled Castes and Scheduled Tribes Lists Modification Order of 1956 under Section 41 of the States Reorganization Act. Stop. Next. Schedule 3 of this modification order substituted paragraph 3 of the 1950 Constitutional Order. Full stop. It said that any reference to the order or to a state or district or other territorial division would be construed as constituted from 1st November 1956, i.e., from the appointed date of the States Reorganization Act. Full stop. Now, the schedule in Part 4 had entry 7. Full stop. This meant that Melghat Tehsil of Amravati, Gadchiroli and Sirocha Tehsils of Chanda district and Kelapur Wani and Yavatmal Tehsils of Yavatmal district were now included in the state of Bombay. Full stop. Entry 27 of the 29th October 1956 modification order now had an entry for Oraon, including Dhanka and Dhangad. Full stop. 1st November 1956 was the date on which the State Reorganization Act came into force. Full stop. Next. Now, leaving aside the subsequent creation in 1962 of the state of Maharashtra, what this tells us is that there were districts in Madhya Pradesh that, on account of the States Reorganization Act 1956, came to be taken out of Madhya Pradesh and included in the state of Bombay. At that time, that is to say, between August 1956 and before 29th October 1956, the entries of Oraon and Dhangad existed for the state of Maharashtra in the very districts in Madhya Pradesh that were being brought into the state of Bombay. Next, necessarily and logically, this would mean that any Dhangars in Madhya Pradesh, in those Madhya Pradesh districts, would therefore automatically become Dhangars in the reconstituted or reorganized state of Bombay. Full stop. Next. Nobody has ever challenged the entries in relation to Madhya Pradesh in regard to Oraon or Dhangad, or suggested that those entries were an empty class. Full stop. That is not a presumption or an assumption that we can make. Full stop. The mistake in the petitioner's entire argument is to move directly from 6 September 1950 to 29th October 1956 without taking into account the geographical delimitation and reorganization of the states by which certain districts in Madhya Pradesh, in the erstwhile state of Madhya Pradesh, were absorbed into and made part of the state of Bombay. Full stop. Logically, it would follow, comma, therefore, comma, that if there were indeed any Dhangars in Madhya Pradesh, open brackets, and this is not under challenge before us at the cost of repetition, comma, then what we began to call during arguments, these Madhya Pradeshi Dhangars would necessarily become Dhangars in Bombay. Full stop. The answer, sorry, this is important because as we have seen, there was more than one basis for the Supreme Court decision in Basavalingappa. Full stop. Not only was there no dispute about the class being empty, i.e., there being no member, there being no such caste as Bhovi at all, comma, this was also pegged to a situation as it existed before the States Reorganization Act of 1956. Full stop. The differentiation in our case is clearly that there is very much a dispute about whether Dhangad was a non-existent community prior to the States Reorganization Act 1956 and, comma, in any event, comma, before the October 1956 SC/ST lists modification order. Full stop. Next. What the petitioners apparently ask us to do is to conflate the concepts of the state of Bombay in 1950, then the state of Bombay after the States Reorganization Act, with the state of Maharashtra as it stands today. Full stop. That is a very difficult proposition to accept. Full stop. Those boundaries have in fact altered in time, and not once but twice. Full stop. We are of course concerned with the first of these in 1956. Full stop. Next, in the course of arguments, that there was a mention that the record shows that there was only one claimant, and that this claimant was nowhere near the northwestern parts of Maharashtra, which would have come to it from, but was in the Aurangabad area. And that too was finally found to be an Oraon. Full stop. that will not carry the petitioner's case much further. Full stop. Next. What happens as a result of this is that on these two determinants running in parallel, comma, VIZ full stop, comma, the entire Khilare family disavows and their claim, all made very recently in 2023, and the failure to explain the consequence of the States Reorganization Act, it is not possible to hold that this case meets the Basavalingappa requirement or test of a zero-member undisputed class. Next. Indeed, what we are being asked to do is to take evidence whether the class was or was not empty, or even worse, whether it should now be deemed or should be held to have been empty in 1950 or just prior to 1956. Full stop. And that is not an endeavor that is permissible in our reading of the decision in Basavalingappa. Full stop. Next. On an objective understanding, Mr. Khambata's argument really is this, that if the presidential order mentions a tribe, but there is no tribal, the court is surely not helpless. Full stop. What we are being asked to do is to construe an entry, not to include or exclude it, and to find the tribe which is, in his words, most likely to have been the reference intended in the presidential order. Absolute numbers may not be dispositive, but it is certainly true that the existence of even a single element in the Dhangad community will render the class non-empty. Full stop. Mr. Khambata was at some pains to take us through various entries for Bihar and other areas, and to say this was not a question of transliteration. Full stop. There was also a reference to the 1976 Amendment Act, which mentioned Orao, Dhangad. And the suggestion was that the differentiating comma meant that these were two separate classes. Full stop. It is difficult to see how this could take the matter much further. Full stop. The submission is really that in 1956, there was no Dhangad at all in the state of Bombay. And there was no material, and there is no material to show there was. Full stop. Mr. Khambata would have us look at what he describes as mountainous evidence to show that the reference intended was to Dhangad. Full stop. The written submission says that between 1837 and 1956, there is not a single official document or record published by any official body referred to as the Dhanagar tribe as being in existence in Bombay state. Full stop. That is the submission in paragraph 21 at page 11 of the written submission. Full stop. But if we, sorry, the submission goes on to refer to a note on exhibits where various official sources have been documented, census reports are considered, and there is a reference to what is said to be an authoritative text in regard to the Dhanagar community. But this is nothing but an invitation to enter into forbidden territory. Mr. Anturkar's argument is precisely this, that no matter how voluminous or mountainous this evidence, this court cannot possibly examine it except in that one exceptional and peculiar circumstance outlined in Basavalingappa itself. Full stop. Mr. Kabata's, sorry, this is not the end of the difficulties by any means in the petitioner's way. Full stop. Mr. Kamata endeavors to get over the next immediately obvious problem, that of a binding judgment of a division bench of this court, by taking us to the Supreme Court decision in state of Orissa versus Dasarathi Meher, D-A-S-A-R-A-T-H-I, Meher, M-E-H-E-R, 2018, 18 SCC 176. Full stop. Now, this is a judgment that undoubtedly looked at the earlier decision in Basavalingappa. Full stop. Dasarathi Meher is the judgment of a two-judge bench of the Supreme Court. Full stop. It was clearly bound by a five-judge decision in Basavalingappa. Full stop. If it is Mr. Kambata's submission that despite Basavalingappa, the Dasarathi Meher court proceeded to inquire into the appropriateness of a query, then that submission would have to be rejected because it would amount to saying effectively that Dasarathi Meher was per incuriam. But that is not what the court did at all, as a very brief discussion will demonstrate. In paragraph 10 of Dasarathi Meher, the Supreme Court considered the decision in Basavalingappa. Full stop. It also considered a constitution bench judgment in Bhaiyalal versus Harikishan Singh, AR 1965, Supreme Court 1557, where the claim was that the Dohar caste was a subcaste of the Chamar caste. Full stop. The Bhaiyalal Constitution bench held that no such inquiry was possible. Full stop. Then there is the third Constitution bench judgment, well known to us in this state, in the state of Maharashtra versus Milin, 2001, 1 SCG, page 4, where the scheduled tribe was Halba/Halbi, and where the High Court held on some material that Halba-Koshti was included in Halba or Halbi. The Supreme Court held that this was impermissible. Full stop. It called out in Milin. 5 propositions, and these are reproduced in Dashrathi Meher in paragraph 12. These are the observations of the findings of the Supreme Court in paragraph 36 of Millen's case. Full stop. They read as follows. Atta, Dashrathi Meher judgment, paragraph 12. The quote number quote kara, the paragraph. Now, as we have seen, the Millen decision clearly held the division bench judgments of the Supreme Court in Bhayaram Munda versus Anirudh Patat, TAR, 1972 SCC 825, and Dina versus Narayan Singh, 1971 38 ELR 212, did not lay down the correct law. Full stop. The Dashrathi Meher Court noted that in Millen, the Constitution bench of the Supreme Court reaffirmed both Basavalingappa and Bhayalal. Full stop. Next. Paragraph 14 of Dashrathi Meher is the one where the court held that the power of a court was limited. Full stop. A court cannot modify, alter, add to, or subtract from the presidential order or a parliamentary notification. Full stop. But it went on to say that at the same time, the court has to ensure that the order is so read in such a manner that no caste or tribe intended by the president or by parliament to be included is actually excluded. But that is precisely what Basavalingappa itself says. Full stop. Next. The discussion in Dashrathi Meher was about 2 other scheduled tribes, namely Kuli and Kulis, KULI. Full stop. The concern of the court is reflected in what is said in paragraph 27 of the Dashrathi. This again is a phrasing that traces back to Basavalingappa, to paragraph 7 of Basavalingappa. For the Dashrathi Meher court noted that the state had failed to show that there was any community, caste, or tribe known as Kulis, KULIS. The only community known was Kuli, KULI. Full stop. Then in paragraph 28, the Dashrathi Meher division bench of the Supreme Court referred to Basavalingappa again and held that the case before it was very similar because the state had failed to place any material on record to show that there was any caste or tribe by the name Kulis, KULIS. Full stop. The court therefore concluded that the word Kulis was simply a plural for the term Kuli, KULI. Next. Correctly read, the Dashrathi Meher is not at odds with Basavalingappa. Full stop. It does not break ranks with Basavalingappa. Full stop. It could not. Full stop. It proceeds on an identical footing that the entry is a 0-member class and therefore some meaning and heft must be given to the entry in the presidential order. Full stop. Next, it would be a mistake to believe that the evidence must necessarily come from and only from the state government. Full stop. That is not a requirement. Full stop. Once there is material before a court, and this material is adequate, to dislodge the case that the entry in the presidential order or the amending act is empty or a zero-member class, then the Basavalingappa door must be held to have slammed, SLAMMED, shut. Full stop. Next. The fact that there is not a single Dhangad petitioner will make no difference one way or the other. Full stop. Next. Right, there is another judgment, is 2006 for SCC, is 98, given by Kambata, not in the compilation. But that's okay. This takes us to the next question, and that is of the division bench judgment of this court sitting at Aurangabad in Prakash Prabhurao Kokane versus State of Maharashtra and others, 2000 SCC Online Bombay 158, 2001 SUPT brackets number 1 close brackets Bombay cases reporter 195. Full stop. The judgment is clearly in the present petitioner's way. Full stop. If the same issue was canvassed there and was decided against the present petitioner's submissions, then these petitioners before us would have to show us that the Kokane judgment is per interium. So we made it clear at the outset that even if we were persuaded to disagree, that would not necessarily allow us on any sound principle of stare decisis to simply hold that Kokane was per incurium. So we would have had to refer the question to a larger bench. Full stop. Perhaps by way of abundant caution, the petitioners have also sought a review of the Kokane judgment. Full stop. But before we consider those consequences, it is important to see what was before the court in Kokane and how that came to be decided. To put it bluntly, this very issue of Dhanagar versus Dhangad was before the Kokane court. The petitioner Prakash passed his 12th standard examinations in 1986. He wanted to take admission to a veterinary college in Parbhani. Full stop. His marks were insufficient. Full stop. He joined the Devgiri Science College in Aurangabad in the first year BSc course. Full stop. He still desired to join the veterinary college. Full stop. He contended that he was a Dhangar by caste. Full stop. He also said that Dhangad was one of the oldest original tribes in India, and then went on to say that Dhangar is known by different names in different parts of the country, and Dhangar is often known as Dhangad. He claimed that the government of India assumes this difference in spelling. Full stop. He therefore contended that the two words are used interchangeably and that they are one and the same. Full stop. Next. He also argued that the earlier state of Bombay included parts of the previous states of Hyderabad, central provinces, and there are from Madhya Pradesh and even the Mysore state. Full stop. He accepted that the original presidential order of 1950 did not include Dhangad in the list of scheduled tribes in any of these states, except in Madhya Pradesh. Full stop. That is important for our purposes. Full stop. Orao was included as one of the scheduled tribes. Full stop. Next. After the 1956 SC/ST Amendment Act, in Madhya Pradesh, there was the entry of Orao, including Dhanka and Dhangad. His entire case was that when these districts from Madhya Pradesh were merged into Maharashtra, Orao, including Dhanka and Dhangad, were shown in certain tehsils that were formerly in Madhya Pradesh. Full stop. But no census report of 61 or 71 ever mentioned a population of Dhangad in Maharashtra at all. Full stop. This is precisely the case of the petitioners before us today. Full stop. Konkani therefore contended that the Dhangad scheduled tribe does not and never existed in the state of Maharashtra, or if at all it exists, it is nothing but Dhangad. Full stop. He reiterated that the two are the same. Full stop. Full stop. The judgment notes that the government of Maharashtra recognized Dhangad as a backward class early in 1967. Full stop. It was therefore treated differently. Full stop. This also was brought into question before the division bench. Full stop. The judgment of the division bench refers to the entry number 36 of the 1970 Act and mentions the phrase Orao Dhangad without the comma. Full stop. To the reasoning that follows, this makes very little difference. And we do not believe that this is a reason to disagree with the judgment, nor to hold that it is per incurium. Full stop. Interestingly, the affidavit in reply was filed by Dr. Gare, the then director of the Tribal Research and Training Institute, Maharashtra. He was undoubtedly an authority, and much has been said about Dr. Gare's work and how the division bench has apparently misread or misconstrued Dr. Gare's views. Full stop. But yet again, that is a matter of evidence, something that is only possible if one is allowed to look at the evidence in the first place. Full stop. Interestingly, contrary to the somewhat remarkable stand before us today, the respondents denied that there was no population of Dhangad in the census of 1961 and 71. It claimed that there was one recorded Dhangad person in the census report. The state denied that the two are one and the same. Even more interestingly, the state went on to say that even assuming that no certificate was issued in Maharashtra to a Dhangad tribal, that itself would show that the Dhangad tribe was distinct from the Dhanagar caste. Full stop. We say that this is curious because there is nothing at all from the state government to explain how between 2000 and 2017 it has achieved this quite remarkable U-turn on affidavit. Full stop. This will also tell us that it is pointless to rely upon an assertion by the state government that there either exists a Dhangad or that there exists no Dhangad. Full stop. It says one thing in 2000 and an entirely opposite thing a few decades later. Full stop. Both statements relate back to the same period, namely 1956. Both statements cannot coexist. Full stop. Next. Reference is made in the judgment to material from Dr. Gare. Full stop. If we have any reservation, it is whether the division bench could even have looked at this material to begin with. Full stop. But we understand that this was perhaps necessary to accurately set out the arguments before the court. Full stop. We find these in paragraphs 24 to 28 of the judgment, open bracket SCC report, which reads thus. Full stop. Next. Inevitably, there is the reference to Basavalingappa. Full stop. What is important for our purposes is the finding in paragraph 36. Sorry, paragraphs 36, 37, 38, and finally 42. Full stop. Next. The division bench then went on to consider the submissions based on the 1971 census report. It rejected the argument that the two words are used interchangeably. It held as a finding that in Maharashtra, Dhanagar and Dhangad are never used interchangeably. Full stop. Dhanagar, the division bench said, is a community well known in the state from historical times, with a specific occupation and with its own place in the caste system. Full stop. Next, there was some discussion on material in this regard, but we do not think it is important or necessary to look at this. Full stop. The conclusion in paragraph 65 to 65, 66 and 68 is this. Full stop. Next. Next. In the context of what we have just said about the Khilare family, the observations in paragraph 73 are indeed important. And these are directly relevant to the two writ petitions in the transferred petitions from Aurangabad. Full stop. We have already seen the prayers there. Full stop. In paragraph 73, the division bench in Kokne's case held in paragraph 73. Next. Now, it is difficult to see on what basis it can now be urged or argued that Kokne is incorrect or is per incurium. Full stop. From our perspective, perhaps there is one aspect that was not spelt out as clearly in the Kokne judgment as we have done today, which is to define narrowly the set of circumstances in which an inquiry is permissible following Basavalingappa and Bhaiyala. That circumstance is only when there is a zero-member class. The reason is, as we have said, that no presidential order and no entry in a presidential order can be meaningless or without at least one member of that class. Full stop. This aspect of the matter is, to our mind, dispositive so far as the judgment is concerned in Kokne's case. Full stop. But of equal importance here is, now Mike will have to find another one. Sonone. Wait. The Sonone is in the other compilation. Wait. One minute. But so many compilations open here just now. Got it. Is the decision of the Supreme Court in state of Maharashtra versus Keshava, K-E-S-H-A-O, Vishwanath Sonone, S-O-N-O-N-E, 2020 SCC Online SC 1040. Full stop. Serial number 7, no?
Page 61.
That's good. Here, a three-judge bench of the Supreme Court had before it a set of appeals against a judgment of a division bench of this court. The Supreme Court said the issues were of seminal importance. and pertained to a scheduled tribe called Gond Govari, Govari, in Maharashtra, included in the 1950 order as amended by the SC/ST Amendment Act, or SC/ST Orders Amendment Act 1976. The High Court had allowed for writ petitions to stop. Now, the claim of Sonone was that he belonged to the Gowari class, Gowari. He said this came under the scheduled tribes. There was no Gond Gowari caste, Gond Gowari inverted comma, in existence. The issue was in regard to a caste certificate which was sent for verification and which came to be invalidated. There were other writ petitions as well. The judgment noted that in 2011, the Gowari community was included in the other backward class category from the common central list in respect of the state of Maharashtra. The High Court had declared that the Gond Gowari tribe was completely extinct before 1911, and no trace of it was found either in the Maratha country of central provinces and Berar or in the state of Madhya Pradesh prior to 1956. It went on to hold and declare that there did not exist any tribe known as Gond Gowari on 29th October 1956, the date of the Constitution, open brackets, ST Order 1950, in relation to the state of Maharashtra. Full stop. It held that the tribe Gond Gowari in the order was not a sub-tribe of Gond. Full stop. Those belonging to the Gowari community could not be denied the benefits of the scheduled tribes only because the Gowari community was shown in the list of special backward classes. Full stop. Next. The submission on behalf of the appellants was that the High Court was in error in tinkering with the entries under the Presidential Order of 1950. Full stop. This could only be done by an Act of Parliament under Article 342 brackets 2. Full stop. The submission was that the scheduled tribe Gond Gowari, included in the 1950 presidential order, did indeed exist and was distinct from the caste Gowari, Gowar. Next. The submission on behalf of the respondents was that it was open to the High Court to ascertain the open quotes true meaning and content of the entry Gond Gowari as included in the Presidential Order 1950. Full stop. Then there were submissions that it was a small hybrid caste and so on and so forth. Full stop. Next. Another submission was that the ratio of the Constitution bench in Millin's case was not in consonance with the ratio in Basavalingappa, and therefore there was a submission that everything needed to be referred to an even larger bench. Full stop. Next. The Supreme Court considered the relevant provisions of the States Reorganization Act. Full stop. It went on to note the 6 different questions that arose for consideration in paragraph 40. Yes, note correct. SCC ऑनलाईन आणि SCC मध्ये पॅराग्राफ नंबर्स मध्ये फरक असेल, पण ह्याच्यात the paragraph begins from the submissions of the learned counsel for the parties and material record. Following questions arise for consideration. तो paragraph आणि त्याचा paragraph त्याचे ते जरा बघायचं ते accurately घेतलं. Next, we are actually concerned here with questions 2, 3, and 4 in Sonone's case. Full stop. Sorry, 1, 2, 3, and 4. Full stop. The Supreme Court noted the Basavalingappa judgment. Full stop. It noted the submission made by the respondents on paragraph 7 of Basavalingappa, which we have already seen. Full stop. Then the Supreme Court considered the Constitution Bench judgment in Bhayalal. Full stop. For our purposes, the relevant portion in Sonone's case, in paragraph 45, is the finding that the observations in Basavalingappa, in paragraph 7, do not dilute the ratio of the judgment in paragraph of that very judgment in paragraph 6. Full stop. The Sonone court held that in Basavalingappa, the Supreme Court had approved of the High Court going into the evidence in the peculiar facts of the case, where the fact was not disputed that there was no caste known as Bhovi in the Mysore state before 1956. Full stop. The Sonone court emphasized this portion. Full stop. It then, in paragraph 48, noted the reaffirmation of Basavalingappa in Bayalal's case. Full stop. It then went on to consider further authorities in that regard, including the decision in Kumari Madhuri Patil versus Additional Commissioner, 1994, 6 SCC 241. Nityanand Sharma versus State of Bihar, 1996, 3 SCC 576. And where the question was about the Lohar community. Full stop. Then it turned to the Constitution Bench judgment in State of Maharashtra versus Milind, 2001, 1 SCC 84. Full stop. Finally, in paragraph 62, the Sonone court said that the inescapable conclusion was that the High Court could not have entertained the claim or looked into evidence to decide whether Gowari was part of the scheduled tribe Gond Gowari. Full stop. There was no conflict, the Sonone court held, between the Constitution Bench judgments in Basavalingappa and Milind. Full stop. It repelled the submission that there had to be a reference to a larger bench. Full stop. It answered questions 1 and 2 as follows. A copy from the bottom part of paragraph 62. Full stop. Next. Then the Sonone court took up questions 3 and 4 together. Full stop. Next. As we have noted, these questions were whether the High Court could have entered into the adjudication and then whether the conclusion of the High Court was supported. Full stop. We are actually concerned only with question number 3. Full stop. In paragraph 69, the Supreme Court held that the High Court could not have entered into the issue as to whether a tribe which is included in the 1950 presidential order did not exist. Full stop. Next. If this be the position in, one. It answered this question in the clearest possible terms in paragraph 84, saying that the High Court could not have entered into the issue, and therefore the conclusion of the High Court that the Gond Gowari tribe had been extinct before 1911 was not supported by materials. Next, the court did consider the additional material. Full stop. At some point, what was cited before this court was the decision of the Supreme Court in state of Maharashtra versus Mana MANA Adim ADIM Jamaat Mandal, which has also been relied on by Mr. Kambata. The Sonone court expressed some doubts about the correctness of the ratio of that judgment. But more importantly, it held that the Mana Adim Jamaat Mandal judgment could not be read as a binding authority to hold that Gond Gowari is not a sub-tribe of Gond. Full stop. The entire decision in Mana Adim Jamaat Mandal was turned on an interpretation of the word including in the presidential order. Next. Before us, there is a considerable amount of other authorities cited, including by Mr. Gangal. Full stop. It is not necessary to consider every one of these. Full stop. We must, however, refer to a more recent judgment of a full bench of this court. हे कुठे गेले ते full bench sir? आता नुकतंच 2023 सेपरेटली दिलं होतं. नागपूर डीबी नागपूर फुल बेंच ते कुठे आहे जरा विचार कोणाचं घरोडे साहेबांचं होतं कोणाचं होतं of the decision bench of the full bench of this court in Maruti MAROTI V. Gaikwad versus Deputy Director Member Secretary, Scheduled Tribe Caste Certificate Scrutiny Committee. That's a citation card. The issue before the full bench also related to the question of permissibility of such an inquiry full stop. The authorities that we have noticed above were among those cited before the division bench. It is perhaps a testimonial to the robustness of our judicial system that Mr. Anturkar was canvassing precisely the opposite before that full bench than what he is canvassing before us today. Full stop. But since Mr. Anturkar submissions did not find favor with the full bench, we will not hold this against him. The full bench judgment is undoubtedly binding on us. Full stop. One of the questions it considered was whether such an inquiry was even permissible. Full stop. This is set out आता हे मला ह्याचं paragraph numbering आणि त्याचं paragraph numbering वेगळंच असेल. मी इकडचं देतो तिकडचं is in the second portion of paragraph 15, just above paragraph 15.1. Full stop. The decision in Bhayalal was also considered. Full stop. Next. The finding at the end of paragraph 15.2 is put in these words. Full stop. Next. We note that Mana Adim Jamaat Mandal was also referenced, as was the decision in Milin and the decision in Sonone. Full stop. Full stop. The court went on to hold in paragraphs 15.11, sorry, 15.10 to 15.12 as follows. Full stop. Next. Now, this is therefore an unbroken line of authority. Going back to Basavalingappa. Full stop. This is not a situation of looking at subsequent facts as sufficient ground for review. Full stop. That would be an indirect way of doing that which Basavalingappa prohibits. Full stop. There is no question today of looking at the Khilare family's subsequent affidavits and disavowals, or the assumption of review jurisdiction by the scrutiny committees. Full stop. It is difficult to understand how a 2023 affidavit by any member of the Khilare family or a 2023 order or a show cause notice based on a 2023 vigilance report can now seek to dislodge school leaving certificates of 1952 and 1953. Full stop. The next, the submission on behalf of the PIL petitioner is based on the 1951 census. Full stop. But this again proceeds on the footing that since there is no Dhangad and only shows a population of Dhangad, therefore the two must be seen as one. Full stop. But this does not explain how the entries for the Khilaris are to be viewed and whether it is possible to arrive at this zero class determination by first taking evidence to see whether the class was in fact zero. In our view, that is entirely impermissible. Full stop. If this approach is to be adopted, then there will be never any end to a reopening of the correctness of every entry in the presidential order. Full stop. We do not believe that that is a sound or a reliable approach in a matter such as this. Full stop. Right. At this stage, for completeness, we note the submissions of Mr. Gangal and Dr. Varamjikar, and in particular their reliance on paragraphs 8 and 10 of the Supreme Court decision in Bhayalal versus Harkishan Singh, 1965 to SCR 877, and in paragraph 7 of the Palghar Villa Khandan Samudaya Jega Asate versus State of Kerala and others, 1994, 1 SCC, page 359, paragraphs 17 to 18. Full stop. Dr. Varamjikar in particular has put together a compact list of the propositions that emerge from these decisions. Full stop. We may fruitfully list these below. Full stop. The obvious are that there can be no inclusion or exclusion except by an order of Parliament, and no modification is possible once the list has been made. Full stop. Nityanand Sharma versus State of Bihar, 1996, 3 SCC 576, also says that synonyms cannot be gone into, open bracket, paragraph 15. Full stop. The Bhayalal decision that we have referred to prohibits inquiries about subcastes. Full stop. No inquiries are possible for modifications in the list, open brackets, Milin, semicolon, Palghar Jilla, semicolon, Bhayalal, semicolon. Glossaries are not to be considered by the High Court. Parsuram and others versus Shivchand and others, 1969, 1 SCC, page 20. No additions or subtractions can be made by a court. Shirish Kumar Chaudhary versus State of Tripura, 1969, 1 SCC, page 20. And a court cannot expand jurisdiction, tinker with the order, vary the constitutional order, make amendments to it, exclude items from it, or take evidence to interpret the entries as they stand. Next. While several judgments have therefore looked at the case law from Basavalingam onwards, come on, we believe all of these point to a single logical postulate. Full stop. It is this. Full stop. The presidential order is sacrosanct. Full stop. It is inviolate. Full stop. It cannot even be modified by a subsequent notification. Full stop. Its entries can be expanded or excluded only by an act of parliament. The rationale for this is what we have set out above. Come on, namely, that in a country as diverse as ours, to define without creating a set of obligations and duties, a law that clearly demarcates a factual position. This is necessary so that further adjustments can be made and provisions made for entitlements, benefits, reservations, and various forms and manifestations of affirmative action. If these entries are to be constantly modified and changed and chopped, there will be resultantly only chaos in the administration. No person will know whether a benefit that is available to her or him today is liable to be taken away by a judicial fiat tomorrow. Full stop. That person will not even know when this unfortunate event will happen or what the consequences are likely to be. Full stop. This is also not a question of only taking away of special benefits or privilege. It is also a question of demarcating boundary and defining which category or class is entitled to what particular benefit. A classic case in point, in fact, is right before us in the form of the Skillare family. Full stop. As we have seen, their affidavits show that their caste certificates are not recent. Full stop. Their validity certificates are not recent. Full stop. Only their disavowals are recent. Full stop. It is entirely unclear to us what is to be done about all the many advantages that they may well have received within that time. It is very easy for these persons to say that they will face a prosecution. But that is not the end of the story. Full stop. If a person has received a benefit on a certain basis, then somebody else has been denied that benefit. Full stop. This is not a situation where there is no sufferer as a result of somebody accepting the benefit under a particular class or category. Full stop. The attempt now to disclaim documents of 1952 and 1953 is even stranger because it is these very persons who relied on those very documents to obtain their certificate. Even more curiously, the affidavits filed in March 2023 do not anywhere say that the school leaving certificates of 1952 and 53 or the vigilance reports of that period were false, fabricated, or in any way defective. The Khilare family could hardly be heard to say this, so that would be entirely contradictory, and would result in all kinds of penal consequences immediately being visited on them. These are precisely the perils of adventuring affidavits like this. Full stop. Next. But these Khilari affidavits themselves, and even without the documents that Mr. Anturkar has referenced in volume 2 of his compilation, prove the point that the class was not empty. For, self-evidently, if that class was empty, there was no reason for the Khilaris to make the affidavits disclaiming their membership of that class. Next. But Mr. Anturkar has correctly not stopped with accepting the affidavits of the Khilaris and founding his arguments only on that basis. Full stop. His compilation shows clearly the documents and the entries that were made decades ago prior to the 1956 ST Amendment Act. Those documents are not even mentioned in the Khilari affidavits. Full stop. All that we are told by the third generation Khilari is that the first and second generations were under some wrong belief or wrong impression. Full stop. We do not know how a grandson can possibly say that his grandfather was under a mistaken belief about an entry he made in a school leaving certificate. Full stop. Next.
Leaving certificate is known by the school, not even by me.
No, he says he mentioned the name, they wrote it like. No, that's correct. But what did he do about it?
Correct. And he
No, but a much more interesting question, which we will only pose because the answer clearly suggests itself, is when the Khilaris awakened to this realization that everything that they have obtained just now is only an illusion or perhaps a delusion. Full stop. Next. We have not understood the Basavalingappa case to be in any way an outlier or an exception case. Full stop. We have read it to mean that it defines precisely and unambiguously the extremely constricted circumstances in which alone a court may and indeed is duty bound to step in and provide meaning. That circumstance is solitary and it only happens when the class is admittedly a zero-member class, because such a thing, i.e. a zero-member class, cannot be allowed to continue in an immutable and unalterable presidential order. That is really all there is to it. Next. In light of this discussion, we have little hesitation in holding that WP 4919, we have no hesitation. 4919 of 2017 is entirely without merit. Full stop. It is dismissed. Full stop. PIL number so and so is also dismissed. Full stop. The three individual petitions, transferred and which assail the caste validity committee's orders and require that certificates be issued as a Dhangad scheduled tribe are also all dismissed. Full stop. Next. The Tribal Rights Protection Committee petition really only seek a dismissal of the PIL and the Maharani Ahilya Devi Samaj Prabodhan Manch writ petition. No separate order is required in those petitions. Accordingly, these petitions are disposed of in these terms. In the facts and circumstances of the case, there will be no order as to cost. What is that?
But if your lordships may not certify that the question involved is a substantial question of law as to the interpretation of the constitution. Your
No,
lordships
we'll
are not-
send you back to Basavalingappa.
Your lordships
It
are
was
not-
refused there, we'll refuse it
May I
here.
only, my lord, say this. Your lordships are not required to say that it's required to be decided by the Supreme Court. That, my lord, it's of general importance. Only if a substantial question of law arises. My lord, that's
Mr.
all the-
Doctor, at this point, Dr. Chandrachud is persuaded to submit that we should grant certificate of leave to appeal.
No, my lord, not the certificate of leave to appeal. My lord, would your lordship see
134A.
No, my lord, 132(1). My lord, it's
No,
only
but
a
which one are you
certificate.
pressing?
My lord, please see 132(1), my lord, for a moment, if your lordship see.
But that's where 132 you do.
If the High,
Supreme
no,
Court.
not- if the High Court certifies under 134A that the case involves a substantial question of law as to
No,
the
no, 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 no,
interpretation
no,
of the
no.
Constitution.
Mr.
That's
All right. Dr. Chandrachud makes a submission based on Article 132, read with 134-A of the Constitution of India that a substantial question of law arises. Full stop. We disagree. Full stop. That question of law arose in 1965. Full stop. It has been decided then and has been reiterated repeatedly. Full stop. It was decided by this court in Kokne's case. Full stop. It has been decided by a full bench of this court. Full stop. There is not the slightest possibility of us acceding to this request. Full stop.
Apart from the repetition, we are Roshni kindly instruct that issued over repetition 1694 and Purushottam Dabboy's repetition 1699. These are similar to repetition.
Those dismissed. You said dismissed. The individual petition.
Petition changes after repetition. But so the-
All right, that's clear. The other two individual petitions also dismissed. It's all right. We'll do it. We'll do it. All right, dismissed. We express our thanks to our appearing counsel, Nachi Navagya, for their assistance. Yes.
We must say, it's for implementation of the articulate task, and we are getting a good result. Completely all the points that-
What is it? We have to do- It's our job.
It is not that
That's-
simple.
This is where your taxpayer money goes. It's fat salaries that we get.
And one go.
Huh?
Because
That's the one. Want to do it, though? What is that?
Like,
तर ते कोणतं आहे बाबा मला ते नंबर काय त्याचे प्रेस काय होते काम रे ते प्रेस दाखव त्याचे प्रेस व्हॉट इज द प्रेस आपण this one. See, Mr. Varnavika, that we set out the prayers in the morning, but that we'll have to set it out. That we'll have to do at the end because I can't remember it now. But that will all be covered. So therefore, we said petitions are dismissed, respondents succeed. All very true. All right. Not at all. Not at all. Okay. Tell us.